Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Sitting in court earlier this morning, phone starts blowing up. A bunch of people texted me saying, oh my God, we got a ruling in the Vanderstock case. That's right. Here it is from the United States Supreme Court. This is a challenge to ATF's rule on unfinished frames and receivers. It did not go well. That might not be a surprise to people who are actually geeking out on this case back at the time of oral arguments. Is this a devastating blow? Is this really a big nothing burger, or is it somewhere in between? Well, we're going to break that all down for you. We're going to try to do a quick skim over the top of the case, give you some of the bullet points so you can get your head around this. So today, let's spend a few minutes and let's talk about, ouch, the Supreme Court upholds ATF's frame and receiver rule. Okay, America, the case we are talking about today is now called Bondi v. Vanderstock. It was called Garland v. Vanderstock. This was a challenge to ATF's rule on unfinished frames and receivers. It was successful at the district court level. It was successful at the Fifth Circuit Court of Appeals. It has now been reversed by the United States Supreme Court by a vote of 7-2. That's right. There are only two dissenting votes here. Justice Alito and Justice Thomas, okay, which means you have three theoretically conservative justices that have joined the majority here in upholding ATF's rule for some things. And that's going to be the kind of confusing part about this. Now, just so you understand that this was a little bit of an uphill battle, understand that this was a facial challenge, which is a very lofty burden, to 27 CFR 478.12 as being inconsistent with the Gun Control Act through 18 United States Code Section 921. Put other ways, the ATF was now regulating things that the Gun Control Act had not given the ATF authority to regulate. The Supreme Court, and this is important, has found that because this is a facial challenge, you would have to show under no circumstance could this law ever constitutionally be applied to any set of facts, okay? And the Supreme Court can't go that far because they are clearly saying that there are some unfinished frames, receivers, kits, and things like that that are so close to being completed firearms that, yeah, absolutely positively, the ATF has the ability to regulate that. Section 478's provisions addressing the weapon parts kits are not facially invalid under 921A3A. That subsection contains two requirements. A weapon must be present, and that weapon must be able to expel a projectile by the action of an explosive designed to do so or susceptible of ready conversion to operate that way. Some weapon part kits meet that description. Okay, and now many of you are like, okay, so where is the line drawn? Well, the court didn't clearly delineate the line. And clearly there may be some manufacturers of unfinished frames and receivers who believe that their business survived. If you are Polymer 80 today, you had a bad day because the Supreme Court went on to then state, consider, for instance, Polymer 80's Buy, Build, Shoot kit, which contains all necessary components to build a semi-automatic pistol and can be assembled in about 20 minutes using common tools. And then a new phrase to be introduced to us, artifact nouns. What is an artifact noun? Well, that is actually how the majority helped get to the conclusion they got to. They stated that kit qualifies as a weapon because, one, artifact nouns like weapon often describe unfinished objects when their intended function is clear, as with a disassembled rifle. Two, the statute treats starter guns as weapons, though they require conversion work. And three, the statutory text contemplates that some things short of fully operable firearms qualify as weapons. And again, Justice Gorsuch, writing the majority opinion here, says that the degree of completeness or the amount of work necessary to get it to a completed stage is an important component of this inquiry. The kit also satisfies the statute's second requirement, as it requires no more time, expertise, or specialized tools to complete than a starter gun, which the statute treats as readily convertible into a functioning firearm. While other kits may be so incomplete or cumbersome to assemble that they cannot fairly be described as weapons capable of ready conversion, the facial challenge fails because kits like Polymer 80s clearly qualify. And for all of the manufacturers and or FFLs that are still able to deal in these products, I want you to understand that that is a massive gray area where the ATF, depending on how they're running, but how the ATF could completely run amok. Okay, that is literally like putting them in a dog pen and then taking the leash off of them, okay? Because there's a lot of gray area for them to play with as to what qualifies, well, converted enough. And the court relied on the fact that this language, readily convertible, has been in existence in the statutory scheme for a considerable time. As the majority pointed out, ATF has for decades interpreted the statute to reach some unfinished frames and receivers, and even the plaintiffs concede they have no quarrel with ATF's prior practice of regulating those products. Accordingly, the statute authorizes ATF to regulate at least some incomplete frames or receivers that take minutes of work with common tools to complete. And ultimately, because some of these kits, and unfortunately one of the kits that was on the record here was one of those kits that was this close to completion, where the majority has hung their hat today is, while other products may be so far from finished that they cannot fairly be described as frames or receivers, the facial challenge fails because the statute plainly reaches some partially complete items. Now, you will recall that we, as well as other people, had expressed concerns like, listen, if this readily convertible can be just moved around to other sections of 18 United States Code Section 921, why couldn't it just be then thrown into machine guns? And now we're dealing with a situation where an AR-15 essentially is a readily convertible machine gun because of its easy conversion to that. That argument was made before the United States Supreme Court. The United States Supreme Court kind of brushed that off in this way. Plaintiffs' arguments about the linguistic differences between Sections A and B and potential unintended consequences under the National Firearms Act are unpersuasive. The government represents that AR-15 receivers do not qualify as machine gun receivers, and this court's analysis of the Gun Control Act does not suggest ATF has authority to regulate them under the NFA. Okay, so I want you to think about that. The government promises that they're not going to do it that way, and we really don't think that's how the statute works. That's the best answer you're getting on that today, and that's the best answer we're going to get for now. Okay, now America, understand, some people are going to say this is a crushing defeat for the gun rights movement. Other people are going to say it's not that big of a deal. What's our opinion? Well, take it for what it's worth, but it's kind of somewhere in the middle, and let me explain why. Understand that this challenge was really in many ways doomed from the get-go. Why is that? Well, first of all, this is a facial challenge to a statute, which means that you now have to prove that under no circumstance imaginable to man could this law constitutionally be enforced. Well, the problem is that some of the kits that were then part of the record here were this close to completion. And so what the court essentially said is listen, you had a huge burden to meet here, and the record shows us that you didn't actually meet that burden, as the court put it. As presented to us, this case does not ask us to resolve whether ATF's new regulations in Section 478.11 and 478.12 may be lawfully applied to particular weapon part kits or unfinished frames or receivers. Instead, the plaintiffs have pursued what the lower courts called a facial pre-enforcement challenge to the agency's authority to regulate any weapon part kits or unfinished frames or receivers. So with that incredibly lofty burden, the Supreme Court has come down on it this way. The Gun Control Act reaches and permits ATF to regulate at least some partially complete frames or receivers. So, does that mean that ATF has the lawful authority to regulate every single unfinished frame or receiver known to man? No, it does not. That is not what the Supreme Court ruled today. But did the Supreme Court rule that the ATF absolutely positively has authority to regulate some unfinished frames and receivers? It most certainly did. The problem for us moving forward with this opinion is going to be, where's the line? Where do we go from unfinished chunk of material to now almost a frame and receiver where the ATF could now step in? And we really, in many ways, America, end up right back where we started in this guessing game in this spectrum of completeness. Okay, listen, we're going to do a deeper dive and get a video out in a few days where we can really geek out on it. In the meantime, we're going to link up today's ruling down below. It is Bondi v. Vanderstock. Again, For those that watched the oral arguments, we kind of saw this coming. It did not look well. It did not go well. And apparently we were all seeing and reading the same thing. If you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that stuff is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.